Welcome, Ilan Journo here at the Ayn Rand Institute. My guest today is Adam Mossoff, a professor of law at George Mason University. He's an expert on intellectual property law and policy. Now, in addition to publishing in scholarly journals, Adam has written commentaries on patent law that appeared in the Wall Street Journal, New York Times, Forbes, The Hill, Politico, and many, many others, which I won't mention. And he's been invited to testify a number of times before the Senate and the House of Representatives. Now, Adam has also contributed to two recent and excellent books, books of essays on Ayn Rand's ideas. One is called The Companion to Ayn Rand, and the other is Foundations of a Free Society, Reflections on Ayn Rand's Political Philosophy. Welcome, Adam. It's great to have you on the show.
Thank you, Ilan. It's wonderful to be here.
Now, I wanted to talk to you about these two threads in your career. So the major focus in your intellectual life is intellectual property and law, and then the Ayn Rand thread. I wanted to bring those two in together. So let me just set the table a bit about the issues I want to cover. So first, this issue of intellectual property. So I've been thinking about this, and it seems like there's a lot of ignorance, apathy, even hostility toward copyrights and patents these days. Just one example, and you've written about this recently, the former presidential hopeful Kamala Harris was arguing that the government should take over some of the patents that are held by drug companies and just take them away and control them. And, you know, a moment's reflection will realize she's not an outlier. I mean, there's many people like her, not only in politics, but intellectuals pushing for the same thing. And then so on the other end of the spectrum, or the other side of things is people not involved in politics or advocacy, but, you know, your neighbors or people in your dorm room, people you know, who maybe some of the people listening don't give a second thought to the idea of downloading movies or TV shows or music from the internet. They don't give that a second thought. And, you know, but they would never dream of going to a grocery store and grabbing food and just walking out without paying. And for many people, those two things are not equivalent. And I want to just kind of get at that in sort of conversation with you. And so the other major issue I want to talk about is this thread in your intellectual development in your career is this Ayn Rand and her influence, so her ideas, and particularly because a lot of people know her as an advocate for capitalism, but that really was a consequence of her advocacy for rights, and she was a principled defender of rights, including intellectual property rights. I want to get all those things on the table. Well, let's start with, you know, we're going to get into the controversies in a moment, but just tell us a bit about yourself. I gave a very condensed summary of your career. How did you get into the law? I know there's sort of some background that you studied philosophy before that. Just paint a picture of how you got to where you are.
All right, thank you. And I love it, Ilan, how ambitious you are with our little time we have here together. And so I actually was introduced to Ayn Rand very early in my life as a young teenager, and loved her ideas and voraciously read many of her books, all of them ultimately at the end of the day, and really enjoyed them tremendously. And I was, you know, she very much opened up my eyes to the role of ideas in history and individual lives and societies more generally. But I've always had a very practical orientation in the kind of the way I think about the world and how I think about the role of ideas. And I'm also a geek, for lack of a better term, as my friends can well attest. And so I originally became interested in potentially going into academia on the philosophy side, and in particular doing legal philosophy. I thought legal philosophy was kind of where the theoretical rubber hit the practical road, where we would be engaging with kind of the really deep and difficult questions of how you design institutions and legal doctrines on the foundation of principles of rights and theories of government. And I really found in academic philosophy that it really wasn't the case, at least on the philosophy side. And I was, meanwhile, taking courses in law school as a graduate student. As you mentioned, I was studying philosophy actually in graduate school. And I was really enjoying my time in law school. I was really enjoying my law professors and my conversations with my law students. And I realized I was on the wrong side of the academic divide between law and philosophy. And in fact, I was starting to realize more and more that the legal philosophers that I actually enjoyed reading most of them were law professors. And so I realized I didn't want to be a philosophy professor. I really wanted to be a law professor. and applying my ideas. And then, of course, I'm a geek, so what area of law would most be appealing to me? But intellectual property. How could I say no to that? So, and that's kind of got me going in terms of I left my PhD program, and I never looked back, and I got my law degree, and I clerked for a judge, and I was an Olin Fellow at Northwestern, and then I immediately went into being a law professor.
Well, that's really helpful, and I should mention we've known each other quite a while, and I've seen this progression. I've been really impressed by your trajectory in the law. So let's set the stage a bit to talk about some of these concepts. And I agree, maybe we won't get to all the topics I've laid out, but there's a lot here. So let's start with IP and just what are we talking about? So just what exactly are patents, copyrights? What do they protect? Just help us understand that a bit.
Okay, yeah, it's a great question because there's a lot of confusion about it, as you, I think, touched on brilliantly in the opening remarks, on all sides across the political spectrum and by all people. So intellectual property is a general category of property rights that identifies property rights in newly created values in the world. And so when you have a new technology, such as a new process to make a drug, for instance, or a new machine or component of a machine, your smartphone, those are covered by patents. Patents are property rights in kind of new technological innovations and the methods in using those innovations. Copyright covers property rights in newly created creative works. So the Star Wars 9 movie coming out in a few weeks, Marvel movies, books, anything written, paintings, artistic works more generally. And then you have trademarks, which the Nike swoosh and the ARI logo and things of that sort, the marks that represent the value in the marketplace that has been created through the production of products and services by a particular organization. It's known in the law as goodwill. And so trademarks are protected insofar as they refer to the goodwill created by companies that are engaging in valuable productive labors in the marketplace and selling products and services. And then there's trade secrets, which are business information, or actually any information that is of value to a business that they keep secret, will be protected to them as well. These are all different types of property rights that are protected to the various new creations that actually drive our society. I mean, if you think about it for just a moment, everything starts as either a patent, a copyright, a trade secret, or trademarks are eventually developed, but because everything we use in society has to be created by people.
So yeah, that seems like it's a good entry point into the sort of the theoretical perspective on this. So what is the argument for these rights? What is the basis for them? So you say everything begins with that, but I mean, it's a question that could you have a society without these? What would it look like? And what is the sort of arguments for having these rights protected?
Yes, well, so of course you could have a society without intellectual property. Most of human history existed without intellectual property. Most of human history existed without property rights. And we kind of have a good sense of what happens when you don't have societies that protect people's rights of life, liberty, and property, including intellectual property. These are stagnant societies that don't flourish. They don't have economic growth. They don't, people are not as happy and living well. And that's most of human history. And so societies that don't protect intellectual property tend to have more stagnant economies. Their people don't flourish. They don't have as much new goods and new items. Intellectual property came into existence. It correlates around the time of the start of the Industrial Revolution. In fact, it was key to the Industrial Revolution in many respects in the United States. All of the innovations that drove the Industrial Revolution were patented innovations. And so it's really fundamental to having a society that grows, that flourishes, that succeeds, is protecting these types of property rights. And so we could have them, just like we haven't had them in society. But it's economists sometimes refer to as the hockey stick graph. The chart of human survival and of economic growth. If you start like 3,000 or 4,000 years ago, and it's relatively flat until about the 18th or 19th century, and then it's almost vertical. It goes right up, and it correlates perfectly with the time that we started to protect not just the rights of life, liberty, and property rights and tangible goods like farms and things of that sort, but the intellectual property that protected the implements that made the farms possible. The invention of tractors, the inventions of the cotton gin, the invention of mechanized reapers, the invention of all the sorts of business methods and industrial methods that goes into having an advanced complex society.
So who, if just as a kind of a signpost for people interested in learning more about this, so who are some of the philosophical founders of this idea of intellectual property rights?
Oh, that's a really interesting thought, because intellectual property, kind of like most things in the law, including even property rights, evolved first as a legal institution and as a political concept before there was a theoretical justification for it. And intellectual property has been very controversial even from its first arising in the 18th centuries. Even among kind of classical liberal thinkers, Thomas Jefferson was very famously a very skeptical or critic of patents. And some people who do believe in intellectual property only believe that we value it because it serves a utilitarian function of increasing social welfare. But there really is truly kind of a foundational view of this, that what intellectual property refers to is kind of the base of all property rights, as Ayn Rand referred to, which is the belief or the recognition of the fact that humans have to produce and create new goods in order to survive. All the values that make our life possible have to be conceived of and then created through our productive labors. And that's what intellectual property refers to. Historically, there really wasn't any true focused justification for this. Ayn Rand, through her ethical theory and her political theory, really was the one who was able to connect this, to make this connection. And in fact, she's one of the very few people who is sometimes classified along with libertarians, who is actually an advocate for and defends intellectual property, because many libertarians are actually very critical of intellectual property and are highly skeptical of it.
I want to get to some of the controversies and the challenges in a moment, but so one thing I've heard people argue, and I want to get your perspective on this, is, so, okay, great. So you wrote an interesting book, or you invented a new mousetrap. Good for you. But then the government grants you this monopoly on it, and if it grants you this monopoly, there's some injustice in that, because, well, why you? I mean, okay, maybe you originated, but why, so I guess what I'm trying to get at is this idea that it's some kind of privilege or favor, and that it's something that, if we sort of the central planner, philosopher king kind of mentality, if we gave it to you, it's up to us to kind of make some decisions about it. How does that fit with your understanding of what is intellectual property?
So this is you're hitting on, I think, one of the very common confusions about intellectual property, that it's this government grant. It's the government stepping in and actively interfering with other people engaging with the use of their property and their goods. But this is one of the key features of intellectual property, if you truly understand, is that you can only get a patent on something new, a new invention. And it's a fundamental requirement in patent law. And you have to prove that you actually created something in the real world. It can't just be a purely abstract idea. So I can come up with an abstract idea of how to make a lightsaber, but me kind of thinking of that it isn't the basis for having a patent. You actually have to have the actual thing that's invented, the real world material value, the technology. And so this is key to understanding this, because there are government monopoly grants, which, by the way, unfortunately, one of the reasons why there's confusions about this is because they were called patents. So the term patent comes from originally what started in England, with the Crown dispensing royal privileges and monopoly grants through a legal device called a letter patent, which was through the law French of the common law, where they put the adjective last. It was a patent letter. It was an open letter from the Crown saying you had a monopoly in something. Of course, good Americans later said, oh, well, the adjective comes first, so clearly letter is the adjective, so patent is the thing that we want to secure. And so that's how we ended up with patents as the term for this. But so this starts with these monopoly grants, but then the clear innovation that occurred in the 18th century was that they took it out of the domain of monopoly grants, because the Crown would grant these for anyone for anything. So playing cards, for example, is one of the very infamous examples that was litigated in the 17th century. But she would grant all sorts of monopolies into crown favorites. She gave them out as matters of largesse and political political payments and things of that sort. And it was starting in the 18th century. This was recognized that no, actually, the type of creative labor that goes into coming up with a new invention is intellectually or at least at a level of principle the same thing as a farmer who spends a year finding a fallow field, tilling the soil, husbanding the crops, reaping the crops, and then taking them to market. That same type of productive labor that goes into a farmer creating a new value, food, is the same type of productive labor that an inventor engages in coming up with something new. And just in the same way that a farmer hasn't taken away land from someone else when they find fallow land, an inventor in coming up with something new hasn't taken away anything from anyone because the thing didn't exist before. And this is Ayn Rand's key insight, is that, that recognizing that reason is man's basic means of survival, and that this is a key feature of what it means to be a rational animal and an individual. It's not just that, well, you happen to come up with it. I mean, you actually engaged in the intellectual labor and the resulting physical labor in the world to produce something new. And that creates a moral claim to that thing, that it's yours. You invented it, you created it. And so you are expanding not just your realm of ways in which you can flourish, you're making everyone else capable of flourishing even better as well through your productive trade in the marketplace.
Okay, so let me put some of these challenges to you. And what I did to prepare is I thought about some of these, and I asked around people I know just to get a sense of what kind of perspectives out there are. So here's one kind of challenge that people have, and I think maybe there's misconceptions here, maybe there's just wrong views. But help us unpack this. So if I come over to your office now and I punch you in the face, now clearly that's wrong, right? I mean, you'd be injured, and there's all kinds of legal penalties that would come up. But if I go and I take one of your articles and I distribute it, violating the copyright and the conditions under which it was published, there's no bruise on your body when I do that. There's no kind of physical harm to you. So what's the big deal, right? Why? And it's not like you can't use your article, and it's not like other people can't read it. So why is that who's harmed, basically?
Yeah, that's a common criticism of intellectual property, that real property and our rights to our body and our rights to our liberty are defined very much in terms of physical interactions. And intellectual property the thing can be copied in the marketplace, and where's the harm? But there's two harms that really arise from this. The first is that you've taken away from me the time and value and effort that I spent in the time that I worked to not only invent this new thing, but also spent the time developing it on the grounds that it's a property right in the marketplace. And so what a lot of people don't understand is that it's key that we protect intellectual property as a property, because that's what also facilitates contracts and commercial exchanges and drives the free market and drives a flourishing innovation economy. And so you've actually, when you take something away from me in the context of copying my book or copying my machine or my new smartphone that I invented, my new technology, you've stolen that period of my life that I spent creating that, knowing that would be something that I would have a property right in, and that I therefore invested my time and energy in it that I will never get back. I will never get back. In the same way that if you take a farmer's crops from him after he's labored on it, you could say, well, you haven't injured the farmer. He doesn't have a bruise on him just because you took 5 stalks of his corn, but you just took a portion of his life that he just spent the last year creating that crop. And the second way that the harm is experienced is that whereas goods are fungible, they're tradable. They're two cars are, 2 Toyotas are exactly the same to most people, and $2 bills are the same to everyone. But when you sell a good in the marketplace, when you're a seller of goods, that if someone else copies that, then you have lost a sale. You have lost the ability to profit from your labors, and profit from the use of your mind and the use of your virtues and the values you're creating in order to live your life and to trade in the marketplace. And again, this is what it means to protect IP as property, as opposed to a monopoly grant, which did just shut people down. The whole point of protecting patents and copyrights and trademarks and trade secrets as property rights, and by the way, this was an American innovation. We were the first country that did this, was because this is what makes them tradable assets in the marketplace. This is what it makes it the basis for people then to use as collateral to get loans so that you can build a factory and you can enter into complex negotiations and contracts. And then you can innovate also more additional commercial developments on top of that. Cyrus McCormick, the inventor of the mechanized reaper in the 1840s, had to also invent installment purchase plans. He invented that because farmers didn't have the money before they sold the crops, but they wouldn't sell the crops until they reaped them with his mechanized reaper. So he had to actually invent this idea, well, just give me a little money now and you can give me more money when you've made even more crops for the use of my reaper. He also invented customer service plans. So farmers weren't trained in how to fix a broken down mechanized reaper. So he had trained Cyrus McCormick engineers who would go out to farmers' fields and fix the reaper. He innovated that because he wanted to deploy his product in the marketplace and sell as many as possible. But it's only possible to do that if you have a property right that's tradable and exchangeable with other people through free trade. And so, and that's what's being shut down by copying and the stealing and the pirating of an intellectual property right.
Okay, so here's a different kind of angle on it. I mean, it flies in the face of what you just said about McCormick, but one kind of argument you hear is when someone gets a patent, say on a drug, or some other kind of scientific discovery, that's throwing up roadblocks to further progress and further innovation. So if we're all on the board with we want progress, clearly at least there's a problem here. What do you think of that kind of view?
So, so again, that's a very common view, and there's several responses to it because it's actually not true even as a matter of law and doctrine. One of the key requirements of the United States in developing its patent system was it publishes all patents. And the purpose of doing that was to make the knowledge in a patent accessible to everyone so that even before the patent goes off term, the property right expires, which all patents and copyrights eventually expire as well, people can read the work and they can develop and build upon that, in which people do. So a company develops a new pill and their patent is published. And so other companies then read their patent. They wouldn't have known how to make that pill, but now they do. But they can't make the pill, but they are then come up with a new method, for instance, for delivering that pill. And if that's a new method that's innovative and meets the other requirements, they'll get a patent on it. And then the two companies, because they're property rights, will trade with each other. It's called a license, where the first company that has the patent on the pill will say, all right, give us a small fee in the use of our pill, and you can then use your method in the marketplace and make even more money. And trillions of dollars exchange hands in our country every year on the basis of these types of commercial agreements where the property rights and intellectual property are being traded and exchanged and negotiated over by business persons who are looking to make money from their innovations and their creations. So it's not true that that intellectual property locks up information. A lot of people say that. In fact, it's the exact opposite. It expands the basis of knowledge, because the alternative to having a patent is trade secret, right? If you come up with something new, if you're not protected in a patent, you're going to keep it secret. And by the way, that's what people did for most of human history, is that they kept it secret. That's why there were guilds. The whole point of what was the point of a guild was to keep things secret. And so they killed people if they disclosed the information. And they recognized that didn't advance human society, that didn't advance human flourishing, and that didn't make it possible for even the people in the guild to live as successful lives as they might live if people actually were able to trade this information as property rights in the marketplace. And so So it's really not true that it locks it up. Now, it is true that while you have this patent, you can stop people from practicing the technology, using it, manufacturing it, selling it in the marketplace. But most people don't for the same because most people want to make money from their patents. This is why people get patents. This is why pharmaceutical companies, which license their patents just as much as other companies do. In fact, I wasn't being hyperbolic. It is trillions of dollars are contributed to the United States gross domestic product every year through pure intellectual property transactions, through licensing agreements. And so they are constantly negotiating with each other and trying to come up with these deals. The reason why you can stop people with an injunction is because you can't have a free market exchange. You can't have contracts if you can't ultimately say to someone, you're not allowed to use my property unless it's on my terms, unless you get my agreement to use it. So someone comes onto your land, you can say, pay me or get off. But if you can't say get off, they're going to say, well, then why will I pay you? And it's the same. This is what underlies all property rights. And so and it's the same idea in intellectual property as it is for land. And so for the same reason that a landlord, people who ended up owning more land than they lived on, and they said, oh, well, I have all this land. I'll make money on it. I'll rent it out. I'll license it to other people. So I'll become a landlord. I'll have other people live on it and they'll pay me for it. That's the exact same principle that's occurring with intellectual property, with patents and copyrights. In fact, if you think with respect to copyrights, movies involve millions of people transacting with each other, with employees and investments and directors and actors and all sorts of people. And they're like little startup companies. That a movie studio is investing money in to hopefully hopefully be successful.
So let's just pause briefly on the Kamala Harris, because you wrote about this, and I thought it was a really interesting perspective. You had a piece in I think the Washington Times recently. So she's no longer in the race for the Democratic nomination, but she's still around. She has a big platform. So what exactly was she arguing, and what was the context for it, and what's your perspective on that?
Right. So there's a panic, or a moral panic is the term, about drug prices right now in this country, and especially in Washington, D.C. And whenever there's a panic about this, where people are screaming at the government, do something, the government always is considering bad things. And patents are the really easy scapegoat for this, because of some of the confusions that you've already identified. People think that people who have patents are holding up the marketplace. People think people who have patents are unjustifiably demanding too much money and things of that sort. And so it becomes a very easy scapegoat, just like, capitalists were an easy scapegoat in the 19th century. They came up with the term robber baron to blame capitalists for things that they weren't to blame for. And there were many falsehoods. The same thing occurs with patents today. And so there's a lot of proposals to impose price controls on patented drugs. And she went even a step further and said, and if companies don't agree with our price control proposals, we're just going to take their patents from them. She actually used the word snatch. We're going to snatch their patents from them if they, quote, don't play by our rules, unquote. And she even admitted that this would be a takeover by the government of the pharmaceutical industry. And it's just, I was flabbergasted when she said this, as many people were, because the pharmaceutical industry, is an incredible achievement in our society. It's only about 100 years old, barely that. And it was born of patents, because it's extremely expensive and it takes many years. So it takes about 10 to 15 years, and it's approximately $2.6 billion in research and development costs in coming up with a new drug before a pharmaceutical company actually makes a single penny selling that drug as a product in the healthcare market. And so patents are what make possible for their ability to enter into licensing deals and to set up the complex commercial mechanisms to deploy these in the healthcare market such that they can make money pay back on their 2.6 billion and continue to reinvest and come up with new miracle cures, which they have. I mean, they turn death sentences into manageable conditions. Hepatitis C, cystic fibrosis, cancers, things that even 15, 20 years ago, you got a diagnosis of, you were going to be dead in 5 years. Today, people are living 30, 40, 50 years because these become manageable conditions. We should be praising pharmaceutical companies, not attacking them. I identified these facts in my op-ed and that it was really, for lack of a better term, obscene that Kamala Harris is engaging in this kind of autocratic, almost socialist dictator type commands, saying, we're just going to take your property from you if you don't agree to do what we're telling you to do. I mean, this is exactly what socialist dictators have been doing through history, and we've seen the results of that. And it was shocking to see someone claiming that they were going to do this to one of our most innovative sectors of our economy that has brought so much good human flourishing to our lives today.
Well, that brings us to some of the work you're doing in terms of being an advocate for protecting intellectual property and consulting and speaking in Congress and so on. So I want to mention you. So you were a founder of the Center for the Protection of Intellectual Property Rights, which was housed at George Mason University. Now you have other projects on the go. Tell us a bit about what kind of issues you've been engaging with, where are you working, what's on your plate outside of teaching at GMU.
Yes. I was a co-founder of the Center for the Protection of Intellectual Property about 7 years ago. I've since turned over the reins to another person. But we started the Center for the Protection of Intellectual Property to counteract a lot of the misinformation and what I always thought were unjust attacks on intellectual property owners, as represented in some of the misunderstandings that you identified in your questions, but also just some open, blatant misrepresentations and unjust attacks on patent owners as well, such as by Senator Harris, very oftentimes intellectual property has been defended solely in terms of social utilitarianism or just purely on economic grounds. So this is a classic example. A lot of objectivists identify this, that the good is always identified as, well, it works. And the moral premise is conceded to the other side. The moral premise is conceded to the collectivists, to people who want to tear down property, who want to attack individual rights. And one of Ayn Rand's great insights is that, no, we should claim the moral high ground. We are not just advocating for something that works. It works because it is right. And in fact, it won't work if it's not right. And therefore, it being right in truth and morally right, is even more important than recognizing that it works. And because people need to know that they're right in order to understand that they can continue to do this and why they should keep doing this. And so we really started the Center for Protection of Intellectual Property, and I continue in my other work with other organizations to make this case, to defend intellectual property, not just because it works, not just because it facilitates commercial transactions and grows economies, but because it's right morally, just like it's right morally for us to protect everyone's rights to life, liberty, and property, as the founders recognized in creating this country. And they recognized in protecting intellectual property. In fact, a lot of people don't realize that the only place in the entire Constitution proper, so pre-Bill of Rights, the Constitution that was written in 1787 at the Constitutional Convention in Philadelphia, the only place where you'll see the word right even used is in the clause authorizing Congress to enact copyright and patent statutes, where Congress is authorized to secure the exclusive right to inventors and authors. So it's a really significant insight by the founders in this country that this is a property right that is deserving of protection. And so we engage with in the law. So I've written about 35 amicus briefs in the past 5 or 6 years and participated in many others. Amicus briefs you're not a party to a lawsuit. Amicus brief is a fancy Latin for saying friend of the court. So you are trying to offer additional insights to the court that is not being offered necessarily by the parties to the litigation. So I file a lot of amicus briefs in patent cases and copyright cases and trademark cases. I write op-eds. You identified my more recent one in the Washington Times. I also published one in the Wall Street Journal last month, and I published, as you mentioned when you started this talk, in many newspapers and other media outlets. I write what are called white papers, which are shorter, non-academic papers, 20 pages, 30 pages sometimes, on important topics that are read by congresspersons, by staff persons who work for congresspersons and senators, by think tanks and other people in Washington, D.C., where you're trying to have an influence on the academic or on the policy debates more generally. And I organize conferences, and we hold a lot of, I've organized a lot of conferences and continue to host and organize a lot of conferences where we bring people together to talk about these issues, to try to not just share information between academics and to share information between and among academics and industry representatives from the innovation industries, but also to kind of spark people in thinking about, oh, there's all these issues or topics that aren't being written on about how intellectual property works in the real world, how intellectual property is good, and trying to kind of inspire people to, as academics or as intellectuals and as policy advocates, to actually engage in this very important intellectual work in justifying intellectual property.
So we're running short on time, and I want to be respectful of your commitments today. So one more question then. What are some trends you're seeing in sort of the debates around intellectual property? Are you seeing things go in directions you think are good or promising, or what kind of things are keeping you awake at night?
So it's unfortunately, because libertarians are very skeptical of intellectual property, and in fact, many of them are staunchly opposed to it for many of the reasons that you identified in your questions earlier. And of course, the politicians on the left and advocates on the left also are opposed to intellectual property because they're opposed to all property. Unfortunately, because you have this melding of what are typically thought of as two opposing political sides of the political spectrum together on this issue, you've had a lot of political action on this, and there's been a lot of legislation, and there have been a lot of regulations and use of antitrust and court cases that have diminished, weakened, and even outright eliminated many intellectual property rights in the past 10 or 15 years, and it's a real serious concern. It's a real serious concern. There are entire companies in the biopharmaceutical industry that are shutting down their research and development divisions because they can't get patent protection anymore. And why would they invest $2.6 billion if they're not gonna, they don't have the legal security and a property right that is promised to everyone else? If you engage in productive labors, that you will have the fruit of those labors secured to you under law. Our innovators are being told that they can't have this, that they won't have this, and they're engaging in the action that you would expect them to engage in when they're told that they won't have their rights respected. Is that all right? I won't engage in that activity. I'll go do something else. And the problem is that, as I mentioned earlier, these are 10, 15-year time horizon R&D projects. So we won't see the impact of this for another 10 or 15 years. Of course, new drugs are coming out, and people say, oh yeah, see, we've diminished IP rights, but it hasn't impacted anything. Well, that's because those were drugs that they made investments on and started to create 10 or 15 or 20 years ago. And of course, they're not going to end it at the very end because they've already made the investment, so they're going to deploy those now. But what we're going to see in 10 or 15, 20 years is fewer medical cures, fewer treatments, and people aren't going to necessarily recognize it because of the time difference, that this was because we substantially and very heavily weakened and undermined our patent system over the past 10 or 15 years. This is going to shock you, but venture capitalists now say that patents from China are more valuable to them as bases for investments in new companies than patents from the United States.
Are you kidding me? I mean, I was going to ask you about China as a country where property rights, American property rights are being, or there's a reputation that they're being stolen and ripped off in various ways. You're telling me now that there's protections there that are more financially attractive to investors?
Yes, they actually have stronger protections for patents now that they've implemented over the past 10 years or so than the United States has. And so I've been told this directly by venture capitalists who invest money for massive institutional investors, that when someone comes to them and says, I have a patent, they say, that's great. Where is it from? And if it's from the United States, they're not interested. But if it's from Germany or China, then they say they may be interested. And so we're offshoring our innovation to other countries. Now, of course, China has tons of problems. It has rule of law problems. It's a dictatorship, and we're seeing this even starker terms now in Hong Kong. And so having a great patent system is not going to change that. But it is a problem, though, that this is incentivizing, because they are still accepting foreign investment. So they're incentivizing people in this country to send their money and send their technology and their innovative activities over to that country.
So I heard, I think it wasn't an article by you, but it's an article you mentioned in one of your talks that someone, or maybe this is a commonly known thing, but the American patent system was the gold standard for what sort of level of protection people wanted. So is the takeaway that that's diminishing now, or like it's no longer the gold standard?
Oh, it's no longer the gold standard. Not at all. Yeah, we meaning the country has spent the last 10 or 15 years turning what was a property right system in many respects into returning it back to this kind of regulatory entitlement privilege grant system that it was originally born out of. It's more like now the kind of, the privilege grants from the crown that existed in the 17th and 18th centuries in terms of the lack of stability, the lack of protections, the lack of rule of law. It's been swallowed up by the administrative state, and all of the concerns and problems with the administrative state, with the lack of rule of law and the lack of protections of the rights of property, now have affected the patent system. And so it's widely recognized that we no longer have a gold standard patent system. And it's really a shame. I mean, we revolutionized the very idea of treating patents as property rights, treating all intellectual property rights as property rights. The world came around to our view starting in the 19th century. The United States patent system proliferated throughout the entire world, starting in the late 19th century, when people were marveled at how just productive we were, and wasn't entirely the patent system. It's not reducible just to that, but that was a key factor in it. A lot of people don't realize how impressive it was that, what happened in the 60 years between, 1783 and the 1850s. I mean, we went from being primarily an agrarian country, massively in debt, from the war, that was fought all over the seaboard, or the entire continent at that time of 13 colonies, and without really any significant homegrown industry, to, by the time of 1850, the very first World's Fair, the Crystal Palace exhibition in England, we were marveling the world with the mechanized reaper by Cyrus McCormick, and the telegraph from Samuel Morse, and rubber, vulcanized rubber from Charles Goodyear, and the sewing machine from Elias Howe and Isaac Singer, and the repeating firearm from Colt, and Eli Whitney's cotton gin. I could go on and on and on. All of these were patented innovations. And everyone was shocked by this. They said, what's going on in America? If only they had adopted even more other aspects of our political system, other aspects of limited government and protection of the rights of life, liberty, and property. But at least they replicated our patent system. And because of that, there was greater, distribution and trade and of goods and of new innovations and of new technologies. And we spent the past 10 or 15 years forsaking that. It's interesting that, China, which is, in many respects, a dictatorship and a totalitarian regime in some respects, that it's left the people primarily economically free up until recently, at least. And so they recognize, oh, having a patent system that provides strong property rights is a key to growing our own innovation economy. And so China thinks right now that they can kind of, if they leave people free economically, but control them in other respects, that they can manage that. It'll be very interesting to see how this kind of plays out in the next 5, 10, 15 years. But right now, people think that that's the place to go if you want to actually come up with new innovation.
Well, Adam, we've run out of time. Thanks for sharing your expertise and perspective on this. It's been fascinating. Where can people find out more about your work, some of your articles, and read up on these issues?
Oh, well, my articles, my academic articles, are all on the internet at a website called ssrn.com. If you just Google Adam Mossoff SSRN, it stands for Social Science Research Network. You can find all of my articles available for download PDF. But also, if you just kind of Google my name, invariably you'll see many of my op-eds, and also I have my congressional testimony. My written testimony is also on SSRN. But even more important, you'll find I think all of the videos of the talks that I have given for the Ayn Rand Institute at various conferences over the past several decades, and other talks that I've given as well, such as I gave the Hayek lecture at Duke University 2 years ago on how intellectual property drives innovation economies, talking about the history of the United States as an exemplar of the principle of what it means to protect intellectual properties or property rights. So, yep, you can find me on the internet, and because I'm an academic, I'm very happy to have it out there and available, and people can watch it as much as they'd like.
We'll put links in the show notes to all those things you mentioned. And I'll mention too that, I mean, it's not where you put your scholarship, but your Twitter feed has an interesting feature, which I enjoy. I think on this data and innovation history, where you share the patent applications from different inventions. So with that, thanks for joining us today. I really appreciate your time.
Well, thank you, Ilan. It was really great chatting with you, and really great questions. I really enjoyed it. Thank you.
Thank you.
Thanks for watching. Be sure to subscribe and ring the bell to never miss a video.